Assalamualaikum, salam sejahtera. So today we are going to talk about another very important topic at the public international law, and that is state jurisdiction. This is a very highly contested topic in the public international law, so I want you to really pay attention to this very short and brief discussion. Right. So first, before we move to the discussion on state jurisdiction itself, I want you to think about one incident that Malaysia and Malaysians experienced before, and that is the shooting down of MH17 in 2014. So what happened in this particular case was that basically our airplane was shot down on the Ukrainian soil. So upon investigation, well, there was certainly Malaysian on board of that crashed airplane, but there also Dutch citizen on board of the airplane, UK citizen, and some other countries' citizen as well. Now, I want you to think about this scenario. In that particular situation, who has the right to arrest the suspect, bring the suspect to the court, and administer justice to them, right? So, if we think about Malaysia as citizen of the country on board of that airplane, then on what ground are we trying to say that we have the right to prosecute the perpetrator? And again, the majority of the passengers on board of that airplane is the Dutch. If Dutch government would like to claim jurisdiction, would like to claim that they have the right to bring the perpetrator to the justice and prosecute them, on what ground do they have the right to say that? And if other countries would like to bring the same action against the perpetrators, then on what ground? So today we are going to talk about these justifications, these arguments, these grounds, the reason why a particular state has the right to bring action against the perpetrator in any given situation. So let us move to the first slide. Here we have jurisdiction itself. Now, what comes to your mind when you have the word jurisdiction? We have different ideas given to this particular word, but let us try to confine ourselves to this particular definition. So it refers to the limits of the legal competence of a state, regulatory authority, or institution. We can basically divide the jurisdiction into two categories. Number one is what we call the prescriptive jurisdiction, and number two is enforcement jurisdiction. So what is prescriptive jurisdiction? Prescriptive jurisdiction basically refers to the institution that is given the right to prescribe the law, or somebody call it legislative jurisdiction. All right. So we have the parliament in our country. The parliament describes the law. Now, prescriptive jurisdiction refers to this idea. So it's the power to apply its national law to any person, property, territory, or even wherever they may be situated or wherever they may occur. So it is the power to prescribe the law, what is accepted behavior, what is not accepted behavior, what is right, what is wrong, what is a criminal act, what is not considered as a criminal act. So that is basically prescriptive jurisdiction. So by origin, states who are given the right to decide on themselves, or what we call it, the idea of sovereignty, is given every right and every chance to prescribe the law however they think fit. All right. So all states throughout the world have the right to prescribe what they consider to be a criminal offense or something of different category. So this is the prescriptive jurisdiction. But prescriptive jurisdiction rely heavily on the second category of jurisdiction, and that is enforcement jurisdiction. So it refers to the acts designed to enforce the prescriptive jurisdiction, either by way of administrative action, or somebody call it executive jurisdiction, such as arrest or seizure, or by way of judicial action, that is judicial jurisdiction through the courts. So this refers to basically the other two institutions of the government, that is the executive and the judiciary. So the state can prescribe law, but whether it can enforce the law through administrative action or through court depends on the enforcement jurisdiction itself. So it varies from one state to another. And when we talk about jurisdiction, when we talk about act, when we talk about certain conduct of state, we basically refer to the criminal act of a person, of a state in this discussion. There are also discussions concerning civil action of the state or civil action of the individual, but we are not concerned much about the civil action of the state or civil action of the individual. We would like to confine ourselves with the criminal action of the state. Now, when we classify our discussion into criminal jurisdiction, we are basically talking about the domestic law. So, states design their own law. Parliaments or Senate or whatever name you call it prescribes the law, and international law imposes limited restriction on those laws prescribed by the state itself. Why? Again, it refers to this idea, sovereignty. International would like, as much as possible, not to limit, not to restrict the states exercising their sovereignty, their jurisdiction. All right? Now, there may be situations where one particular state prescribes law as prescribe a certain act to be a criminal act under state A, for example, but state B doesn't consider the same act to be a criminal act. So what would happen if the suspect is arrested in state A just now? Would state A be able to prosecute the suspect? So here comes the international law. International law would decide whether the suspect who happens to be committing an act which is not a criminal act in his own state, but a criminal act in the state he visits, whether the state just now has the right to prosecute the suspect. All right? So this is our concern today, basically. Now, we have 5 principles which basically serve as the meals that the state have to choose from, the menu that the state have to choose from. Let's say the state would like to prosecute a person. Now, the state has to choose from here the territorial principle, nationality principle, passive personality principle, protective principle, and universality principle. The state has to decide whether they would like to prosecute the suspect based on, for example, the nationality principle. And he has to provide argument. He has to justify, the state has to justify why this is the concern that, why this is the concern that the court must consider in allowing that particular state to prosecute. Okay? So, we have 5 principles here. Right, and I put here description. Territorial refer to the place where the offense was committed. So, for example, just now I gave you state A and state B, where drug trafficking may not be, or bringing drug, having in a possession drug may not be considered as a criminal offense in one particular country. But when the person concerned is in KLIA, for example, it can be considered as drug trafficking in our local law, right? So, if Malaysia would like to prosecute the suspect just now, who happens to be the citizen of a foreign country, the citizen of another country, whose drug trafficking is not a criminal act in his home country, may decide to use the territorial principle to claim jurisdiction over the suspect. Right? Now, nationality principle refers to the nationality of the person committing the offense. So, you look at the passport. The passport says to which country this person belongs to. So, if it belongs to country A, country B, or country C, then you refer to the country itself, right? So, bribery in Singapore may be committed by a Malaysian. Okay? So, I'm not saying that bribery is accepted in Singapore, but perhaps different set of rules apply here than in Singapore. So, if Malaysian citizen commits bribery in Singapore, and Malaysia would like to exercise jurisdiction over the suspect using nationality principle, then Malaysia can actually exercise jurisdiction over a Malaysian living or happens to be arrested in Singapore based on nationality principle. But the case is not always as simple as that. All right, I'm just giving you some example here. The third one is the passive personality principle, and that is the nationality of the person injured by the offense. So, border shooting, for example, between these two countries, Thailand and Cambodia. So, when a crime happens, some crimes involves victims, right? So, you look at the victim and you ask question, to whom this victim belongs to. If victims belong to country A, for example, then you can refer to the law in country A. That is the passive personality principle, right? Protective principle. This is quite controversial principle under international law for some reason. One of them is because of the word interest here, national interest injured by the offense. We'll explain that again when we look at the principle one by one. So, a country may have its own interest that it considers as very, very important, important that no other element, no other foreign element can threaten its national interest. So, maybe treason is considered as one of the interests of Malaysia that no one here can tolerate, okay? So, let's say somebody flew to Indonesia and plotted an act of treason against the Yang di-Pertuan Agong in Malaysia, all right? So, this crime basically affects the interests of our country, Malaysia. Now, when it affects the interests of Malaysia, one principle under international law suggests that Malaysia may claim jurisdiction. Whether successful or not successful, that's a different story. All right? I'm telling you here that we have this principle. Now, the last one is the universality principle. Universality principle basically refers to the country who has the custody over the person committing the offense itself. And usually it involves crimes which are regarded as crimes against the entire human being, crimes against humanity. And I gave you here, for example, MT Bunga Laurel in 2011. We have incident piracy. So Malaysia arrested the pirates. Malaysia brought them to our local shore and tried them in our high court. So that is the universality principle. Now we are going to look at them one by one here. The first one is the territorial principle. Now, Lord Macmillan in Christina has beautifully summarized this idea, territorial principle. So he put it as such that territorial principle refers to an essential attribute of the sovereignty of this realm, as of all sovereign independent states, that it should possess jurisdiction over all persons and things within its territorial limits, and it all causes civil and criminal arising this limit, right? So this is basically a summary of what is territorial principle, and it refers to the sovereignty idea itself. When a state has jurisdiction over its territorial limit, and when it captures the suspect, the state has the right to prosecute, the first right to prosecute the suspect. So it is considered as a universal recognition under international law for a number of reasons. Some of them is basically the convenience of the forum itself. When the suspect is arrested in Malaysia, for example, the crimes usually being committed in Malaysia, evidences and everything, the suspect, the complicit, all basically in Malaysia. Well, many cases as well. Nowadays, we have cases like the perpetrator doesn't reside in one particular country, but he commits crime in that country. But that is not the norm still. Most of the time, crimes committed through the ordinary, through the classical means of committing a crime still. So, convenience of the forum refers to the court itself, refers to the procedure, the executive involved, and all other things. The second thing is the interest of the state itself. So if the crime affects the state, if the crime affects the reputation of the state, so the international law consider the state who has the suspect in their custody as being the most affected, and therefore the interest of the capturing state must be given the priority. So the third one is evidences. We know that for a fact that crimes when being committed requires the prosecutor to prove in court all evidences to convince the court that, look, this person has committed the offense and we have all evidences and you should believe our story. Now, evidence is usually available in the place, in the area where the crime is being committed itself. Now, the last one, I want you to refer to Lockerbie case. And for this Lockerbie case, maybe we can do some exercise during the seminar. So please read Lockerbie case, and this basically summarizes the ideas that I've been talking about here. It refers to the territorial principle, the state who has the custody of the person, the state whose suspect happens to be within its territory has the right to prosecute the suspect. Now, when a crime is committed in whole or in part within its territory, now who has the right to prosecute? Let's say a rebel group launched an attack in state A, landed on state B. Okay, so the attack was initiated in state A and completed in state B. Who has the right to prosecute? Now, this is the question. And the law says that when a crime is committed in whole or in part, whether it's entirely committed in that particular state or committed half of it, completed somewhere else, then it is considered as within its territory. But we have two principles here. Now is subjective territorial principle. The second one is objective territorial principle. The first one basically refers to the essential constituent element of a crime which commence in its territory but were completed in another territory. And the second one is the other way around. Commence in another state but completed in its territory. Now, what happened in Lotus case was that the vessel collided in the high seas, brought to the local jurisdiction, and the court considered the offense which was being committed far away on the high seas to belong to the state who has the custody of the perpetrator, right? So in this particular case, basically the court say that although the crime was committed somewhere else but completed here, all right, or the crime which was committed halfway, right, still be considered as belonging to that particular state. Now, what about crimes against humanity? And I want you to refer to the case of Rohingya. In the case of Rohingya, they basically suffered from massive various acts of crimes against humanity. One of them is forced deportation. The regime basically forced them to leave their country, and they have to leave to many other parts of the world. Otherwise, they would face severe consequences, including their life being at stake. So Rohingyas left their country and they traveled, and some of them decided to go to Bangladesh, right? Now, Bangladesh is the country where Rohingya is now in. What happened was that ICC would like to decide whether the government, the regime, is responsible for crimes against humanity. Now, the court has to decide whether Bangladesh can take action against Myanmar for the forced deportation of Rohingya. Now, how that is possible, right? Based on territorial principle again, but which objective or subjective territorial principle? The answer is objective territorial principle. The crime was committed in Myanmar but completed in Bangladesh. The forced deportation was first started in Myanmar, completed in Bangladesh. Now, the state where the offense was completed, that is Bangladesh, has the right to pursue an action in the International Criminal Court by virtue of this principle, territorial principle, specifically objective territorial principle. Now, we have another quite recent crime, cybercrime, which basically a borderless crime, stateless crime. Somebody may sit in one comfortable room and then hack the entire system of another country. Now, what about that crime? We don't have a clear answer to this one case, but can the affected state argue his case in the court based on territorial principle? Now, I leave this question for all of us to discover during the seminar. Next is nationality principle. A state has the right to exercise jurisdiction over its nationals for crimes committed anywhere in the world. So it's exercisable when the national is within the territory of his or her home state. Jurisdiction over permanent resident is the question I put here, but basically permanent resident and the citizen of the state itself considered as same category. So the biggest question is whether a state can prosecute somebody else. A state can prosecute its citizen outside the territorial limit. And the answer is possible. Following the nationality principle, let's say Malaysian committed a crime in Australia, right? So Malaysia has the right to prosecute somebody who left the country in Australia, went to Australia and committed a crime against Malaysian government, against Malaysian citizen or whoever it is, provided that Malaysian authority can capture the suspect, bring him here and try him in our local court, right? So nationality principle refers to the passport of the suspect itself. What about this passive personality principle? So it is basically the opposite of nationality principle. So a state may try or punish foreigners for crimes committed abroad affecting its national. So maybe our citizen happens to be in some other countries, say for example in India. Okay, so a foreign citizen committing a crime against our national in a foreign country. Can Malaysia claim jurisdiction over the suspect who happens to be in another jurisdiction? So the answer is yes. Again, it's the person being affected by the crime itself. The concern here is the person affected by the crime itself, right? So, did states welcome this principle? Well, there is no clear-cut answer again to this question. Some accepted, some did not accept for many, many reasons. Now, we have another controversial crime, that is terrorism itself. Now, terrorism usually committed by somebody who maybe doesn't regard his nationality as important as the ordinary citizen as us, right? So, terrorist group may reside in one particular state, commits crime against another state. So, when we're talking about the passive personality principle, if a terrorist act affects the national of another state, are we ready to surrender the suspect to the other state to charge them? All right? That is if the crime has been committed. But what about a suspect? And it is simply a suspect, not somebody who declare that he was the one behind the attack itself. He was claimed or he was accused of being involved in some terrorist activities, right? So we believe that the claim is basically a baseless claim. So do we surrender the suspect to the requesting state? That is a question. And all this question basically revolves around the nature of the crime. States basically classify the crimes. If it's a pure criminal act, then perhaps not many would object. But if it's like a gray area of crime, such as political crimes, now many states would not be ready to accept passive personality principle and surrender the suspect. But the problem here is, again, just like I spoke to you earlier, terrorism is actually a crime, a political crime. The intention is purely political. So whether a state is bound by the treaty, if there is a treaty, to surrender the suspect when it involves terrorist activities. So we will discuss this question again in the seminar. The next one is the protective principle. What about this principle? So, state has jurisdiction to criminalize extraterritorial acts prejudicial to its national security, territorial integrity, or vital interests, irrespective of where those acts take place or by whom they are committed. Okay, so this is the controversial one. What amounts to security, integrity, political independence, and vital interests? How do you define these very, very vague words? How do you basically exclude certain acts from these words? So, a vital interest of one state might not necessarily be the same as the other state. The same goes with the integrity and political independence. Well, political independence may be some common ideas, but vital interests, that's something which many would argue that their interest is basically not the same as the other state. So, when we have protective principle in place, it suggests that when the state's interest is affected, the state concerned may claim jurisdiction under international law to prosecute the suspect, to have the suspect, to arrest the suspect, and of course certainly to prosecute the suspect. So here we are talking about something which is very, very unclear, but it is accepted under international law as one of the principles to claim jurisdiction. Okay, so let us take one case, Joyce against DPP. In Joyce against DPP, Joyce was an American citizen who had resided in British territory for 24 years. So he applied for and obtained British passport, and after the outbreak of war between Great Britain and Germany, he worked for a Germany radio company and delivered from enemy territory broadcast talks hostile to Great Britain. So subsequently, he was arrested and convicted of high treason. He appealed on the ground that since he was not a British subject, he could not commit treason. The House of Lords held that as a holder of British passport, he owed allegiance to the Crown and was guilty of treason. So the House of Lords in the UK applied the protective principle. So some courts accepted this principle. Some courts in different jurisdictions are a little bit reluctant to accept protective principle on the ground I mentioned to you earlier that all these words are basically too vague to be considered as a clear ground to claim jurisdiction. But anyway, in practical sense, usually states would submit multiple claims, not only one claims, but multiple claims to secure jurisdiction, right? So let us move to the last principle, that is the universality principle. So it refers to the, it suggests that the perpetrator may be prosecuted and punished by any state regardless of territorial or nationality link with the perpetrator or his victim. We have only one condition for this particular principle, and that is forum deprehensionis. Forum deprehensionis is the state who has the custody, who apprehended the suspect. So the principle suggests that look, under public international law, we have a number of crimes which are considered as crimes against humanity, or delicta jure gentium, international crimes such as genocide, piracy, slavery, torture, war crimes, and crimes against humanity. So all these crimes are basically accepted by the international community as a heinous crime, as a prohibited act, as something which no one can commit, which is something forbidden globally. So when it's classified as crimes against the entire human being, so the state who captured the suspect, the state who arrested the suspect, has the custody of the suspect, has the right to prosecute him wherever the crime be committed, whoever the suspect, regardless of the nationality of the suspect and other considerations, as long as the suspect committed these crimes and he happens to be within the hand of the arresting state. So that arresting state has the right to prosecute the suspect. Now, let us move to the two issues that we have when we're talking about different claims of jurisdiction from one state against the other. So a scenario just now I gave you at the beginning of the discussion just now, that we have MH17 being shot down. So a number of states involved. Malaysia is one of them, Netherlands is another, UK is another, and perhaps Russia, Ukraine. So many states involved in this incident. So who has the right to claim jurisdiction? So let's say we have a conflicting claim. Malaysia would like to try the perpetrator, but at the same time, UK also would like to try. Well, on a different principle applied. So who is going to be given the priority to try the offender? That's one question. Another question is, let's say, states cannot basically come to a conclusion who is going to prosecute the suspect, because each would like to try the suspect. But one state decides to unilaterally go into go and arrest the suspect, forcibly arrest the suspect, brings him home, and then try that suspect in the local court of the arresting state. Now, that is called abduction. So, abduction is considered as a violation of international law. Why? Because two main reasons. One of them is territorial sovereignty of another state is now encroached when the state unilaterally, without the consent of the receiving state, go there and then make you arrest the suspect. That's basically without the consent of the consent state. So you cannot simply enter another state without that state consent. That is a very basic principle of territorial sovereignty. So this is against this idea. Number two, international human rights, liberty of a person. For example, under UDHR and ICCPR both speak about the liberty of a person. Liberty of a person basically refers to many things, including one of them is without arbitrary arrest, to live in dignity and not subject to arbitrary arrest. When the arrest was unlawful, when the arrest was made without, not in compliance with international law, that is considered as an unlawful arrest against this idea of liberty of a person itself. So we have this saying, male captus bene detentus, which basically loosely translated as improperly detained but properly prosecuted or properly tried. So do we subscribe to this idea? I believe we don't have to subscribe to this idea, because after all, we are talking about international law, and international requires us all states to respect these two ideas and all other ideas as well. So abduction, male captives, bene detentis is again this very, very basic idea. So I want you to compare between these four cases, McCain, Ekman, Ibrahim, and Bennett. In these two cases, the court seemed to accept the idea that male captives, bene detentis should work. The person may be forcefully abducted, the person may be unlawfully detained from one state, transferred to another state and tried there. These two cases suggest that this principle may work, but the other two cases, Ibrahim and Bennett, the courts in New Zealand and in South Africa seem to suggest that no, in order to prosecute the suspect, the state must come with clean hands. So if the state itself, if the state's hands are not clean, then the state cannot complain that she is not given the right to prosecute. So I want you to compare these two cases, read through carefully, and we will discuss in this seminar. What about extradition? Now, in MH 17, extradition was put to place because many nationals involved and Malaysia surrendered jurisdiction to Netherlands. Why? Well, for a number of reasons. One of them was because Netherlands has most of the citizens on board of the aeroplane, and we consider them to be we consider them to have the right to prosecute the suspect, and for some other reasons. But let's talk about extradition itself. So what is it, extradition? So it is the delivery of accused or convicted to requesting state, and it is done by the state where he happens to be in. Okay, so extradition happens when there is there are two states. One is the requesting state, the other is the receiving state, or the state who would send the suspect. So extradition usually happens when there is any what you call treaties, whether it is bilateral treaty or multilateral treaty between the countries or among the countries. Extradition usually doesn't happen when there is no like a clear-cut treaty which specifies what actions, what crimes involve, and then the suspect has to be surrendered and the procedure and things like that, right? So why extradition is the practice and international law is because crimes now are considered as transnational, and it's cross-border crimes. Many times crimes are committed in one particular area affecting another state. So the other state affected by the crime would like to try the offender. Now, when they would like to try the offender, they must bring the offender home, because that is the idea. The trial must happen in the local court, in the local jurisdiction, right? So in order to bring the culprit before the court, before the local court, the concerned state must request from the state where the suspect is residing. So the state must consent to send the suspect to be tried there. Okay. Now, alternative here we have trial in absentia. In MH17 case, there was trial in absentia. What does that mean? It means that the suspect was not there. The suspect was not physically there. The suspect was not brought before the court. The suspect were considered as somebody who has committed the crime upon all the evidences proven to the court, and the court was satisfied with the evidences tendered to the court that the suspect was actually the one behind all these acts, right? So in match 17, the court satisfied with the evidences tendered before it, and then concluded that trial in absentia can proceed. So trial in absentia in MH17 case. But if, let's say, if they if we have one incident that the criminal happens to be in the other country, and then we would like to request the state to submit the suspect to us, and the state that the concerned state doesn't want to surrender the suspect, can Malaysia basically go to the court and then claim that Malaysia has the right under international law to prosecute, because the concerned state must extradite. Now, we have some other issues involved here, and again, we will discuss in detail during this seminar. All right. So, obligation, no duty if no treaty, bilateral or multilateral treaty may apply here. But some cases, for example, if the state are very sure that when they surrender the suspect, then the suspect would be subject to like unfair treatment, and injustices might happen against him in another foreign land, in the requesting state's court, then is the country being requested has the duty under international law to surrender the suspect, or the state actually is under the duty to protect the suspect. So, general principles for the purpose of extradition is basically the crime must be an extraditable offense, yeah, something which can be extradited from one country to another, same offense, yeah, double criminality, same offense. In state A, this is an offense. In state B, it's also an offense. Specificity, the requesting state can request, bring in court, and then try it, but only the crime which he was alleged to have committed, not bring him home and then try something else, right? Non-political crimes, non-political offense, I think this is quite clear. The states would not easily surrender the suspect for political accusation, for political reasons. The state would usually don't want to do that because reciprocal effect. Okay, if states surrender it, what about the other state claiming that the other suspect also trying to do something against its political interest, and therefore she also has to surrender. Okay, so that's all. I guess we have done with our jurisdiction, state jurisdiction. So there are basically 5 principles: territorial principle, nationality principle, passive personality principle, objective principle, and universality principle. Right. So I want you to go back and read all these principles carefully. Look at my slides and read the cases that I mentioned to you earlier. Try to answer some questions that I posted to you during my presentation here, and we will discuss all those questions during the seminar. Right, so with that, thank you very much, and see you in the seminar.